Good morning. I want to thank you for being here this morning. As I mentioned earlier, our firm represents Ruth Hendricks, who has been a long-time advocate in proceedings before the Public Utilities Commission. We are blessed in California with a form of direct democracy that allows citizens to intervene in public utility cases and to make the case on behalf of their fellow patients. And she has been, over the years, very deeply concerned about the high costs of utilities for those who she serves who are on fixed income. Over the last several months, our office has conducted, on behalf of Ms. Hendricks and ratepayers, an extensive investigation into the practices that Southern California Edison has pursued in charging ratepayers for the defective steam generators at SanOnofre. Many people are concerned about the safety issues at SanOnofre, and we are as well, but our focus today is not so much on safety as it is on the fact that the ratepayers are being charged hundreds of millions of dollars for the defective 4 steam generators at SanOnofre by Southern California Edison in violation of a Public Utility Commission issued order. I have here an excerpt from the order in question. It was issued in December 2005, and it allowed Southern California Edison to proceed with the replacement of the 4 steam generators at SanOnofre. 2 steam generators in Unit 2, 2 steam generators in Unit 3. The then existing steam generators had tubular degradation, had tube defects in them, and Southern California Edison proposed to the Public Utilities Commission that those 4 steam generators be replaced with 4 new steam generators that would cure the tube degradation problem. And the cost was estimated in the approximate amount of $700 million. Because the Public Utilities Commission gave what in essence was a blank check to Southern California Edison, it was required that by the PUC that Southern California Edison return to the PUC and provide an application justifying the cost that they had expended. And specifically, the language says in the order, after completion of this SGRP, which means SanOnofre Steam Generator Replacement Program, Southern California Edison will be required to file an application for inclusion of the costs in rates. The second document, which you have in your packet, is from the 2010 10K that Southern California Edison filed with the Securities and Exchange Commission. Southern California Edison filed this document in February 2011 and stated Southern Cal Edison completed the replacement of the steam generators at SanOnofre Unit 2 and Unit 3 in April 2010 and February 2011. So when you put the original order of December 05 together with the admission that's made by Southern California Edison in their February 2011 10K report for the year 2010, Southern California Edison was required to file a cost application with the Public Utilities Commission in 2011. And in their report, they indicate that SCE is going to file their application for costs, and that's what they say in 2011. We conducted a massive search of the Public Utilities Commission records. We interviewed Public Utility Commission officials, and finally we sent an email, of all things, to Southern California Edison's executives last week, asking them, where's the application that you were required to file? This is the response that they gave us. This is written by Walker Matthews. He is a counsel to Southern California Edison, February 5th, 2013, in answer to my question, has Southern California Edison filed the required application? He wrote, no. SCE has not filed the application referenced in your email below. So that means that what you have to understand is that Southern California Edison charged for the defective steam generators in 2011, $115 million. In 2012, $115 million. And now proposes to charge an additional $130 million in 2013. And they did that by using a backdoor method called an advice letter that was not appropriate under the circumstances. Now and that is bad. That's a serious problem. Any one of you that would have done that in your employment, there's a good chance that you might not be employed where you are. You might have even been prosecuted for theft of funds from your company. But there's something worse than that. If what Senator Boxer has reported is true, it means that ratepayers were charged to replace the defective steam generators with defective steam generators that Southern California Edison knew were defective when they installed them, according to the report that Senator Boxer has made reference to, called the root cause report, that was generated by the Mitsubishi Heavy Industry Company in 2012. Now, if you factor that into it, that the ratepayers were improperly charged in violation of a PUC order, and while they were being improperly charged, Southern California Edison knew before installation that those 4 new steam generators, that there were red flags of defects, and that they chose, the executives of Southern Cal Edison chose not to correct those defects because they were concerned that if they did so, that action would trigger a review by the Nuclear Regulatory Commission and a requirement for a new license, remembering that these 4 steam generators were represented by Southern California Edison to be so similar to the ones that were there that no new license was needed, or no new license amendment was needed. And of course, we now know that there were very significant and severe design changes in those generators. We also know that the 4 new generators that were supposed to last for 20 years, and the cost effectiveness study that was presented to the Public Utilities Commission in the 2004-2005 application, presented a cost effectiveness study that said that these new generators were going to last 20 years. We now know they lasted 2, and we know they could not on their face be cost effective. Now, that's the second point. It's one thing for Southern California Edison to charge for steam generators that they knew had some red flags that suggested that they were defective, and that was in the year 2011. It's another thing to charge in the year 2012 and 2013 when you know that those steam generators are not producing any electricity. They're not even functioning. And you're not going in for a cost application in which you have to show what you did was justified and reasonable. And I charge that Southern California Edison did not go in with their cost application because they knew that they would face an impossible task of showing what they did was reasonable. So the people of California that live in Southern California and in San Diego were charged hundreds of millions of dollars and stand to be charged hundreds of millions more by Southern California Edison for defective generators without going through the required procedures. And the question, arises, at what point does this need to be referred to the Federal Bureau of Investigation? I noted the Nuclear Regulatory Commission made reference to the fact that based upon Senator Boxer's reference and referral of the 2012 root cause report suggesting that Southern California Edison ignored red flags, that the Nuclear Regulatory Commission raised the prospect that they may send this matter to investigation by the Justice Department, I believe that reasonable people could come to the conclusion that the time has come for this matter to come under investigation by the Federal Bureau of Investigation and by the Department of Justice to determine if there has in fact been violations of the mail fraud and wire fraud statutes of the United States. Again, this is not just a question of safety. That is a significant question, and that's a level of expertise that others have that will address that tonight at the Nuclear Regulatory Commission hearing in San Juan Capistrano. But when you charge people for defective products that you know are defective in violation of an existing Public Utility Commission order, and you do that in a surreptitious way, and you do that after you know that they're not generating any power, and you know that you've done that after there's red flags that these were defective to begin with. Let me just ask you this question. How many of you could have done that and gotten away with that scot-free? How many of you could have engaged in similar conduct? You know, not to bring up something that's irrelevant, but I noted this last week that a student at San Marcos, California State University of San Marcos, is being charged by the FBI for a student body election violation associated with the computer system. Is that a more serious antisocial act than what we see here, that these records that are existing? Now, I have packets for you, and what you're going to find in these packets are details. For example, one of the details are the letters, what are called advice letters, that were sent by Southern California Edison as opposed to the cost application. Instead of filing the cost application, in which Southern California Edison justified what they expended, they just simply filed a notification to the Public Utilities Commission and said, here's how much we're spending, but it's all subject to refund. Here's how much we're spending, it's all subject to refund. Here's how much we're spending. They did it 3 times. And so you'll see in here the discussion of that. The other thing that you'll find in here is Southern California Edison has filed sworn testimony in connection with what they call the OII, the Order Instituting Investigation, which was initiated in October of 2012. They've actually filed sworn testimony in which they discuss the possible return of money that they've charged, and they don't mention that they have an existing application to charge another $130 million. Now, in their email to me, they indicate that SCE anticipates filing the application in or around March of 2013. In their 2011 application, they indicate that the CPUC had established a mechanism establishing thresholds for review and recovery of their capital costs. Based on preliminary cost information, SCE does not expect a reasonable review will be required. SCE will file an application with the CPUC setting forth its final cost of compliance with the adopted mechanism. So this was done in 2011. Now, it was, and then of course it wasn't filed. They also filed another document, another 10K, in which they indicated that, and this was their 2011 10K. They said, quote, SCE expects to file an application with the CPUC setting forth final project costs in the 3rd or 4th quarter of 2012. So the point being is that they have represented repeatedly that they were going to file this cost application. They have failed to file the cost application, and now the first time that they've actually admitted that was in an email to an attorney who I think we would all agree has not had exactly a central involvement in the proceedings. So that is, I'm hopeful that by doing this today, that this will spark a greater intensity on the part of the Public Utilities Commission. The Public Utilities Commission has been asleep at the switch. And this has been a pattern of behavior. We've had the San Bruno explosion in which lives were lost, and there was, I think many agree, a very inadequate follow-up investigation. Those of us that live in San Diego know that we had the fires of 2007 and a follow-up that was by the PUC that was wholly inadequate, and had it not been for the San Diego media jumping on that issue big time, we would have faced a very severe imposition of $1 billion of additional rates, which are still hanging over our heads, but that threat looks like it's been removed, at least for now. And then now we have SanOnofre. Again, a breakdown in the Public Utilities Commission's regulatory procedures and actions. We have 5 commissioners of the Public Utilities Commission who are extraordinary people. One is a graduate of the Woodrow Wilson School for Public Policy. We have 2 Oxford University Rhodes Scholars. We have 1 financial banker expert with extraordinary career. And we have President Peavy, who is a former executive of one of the utilities and a very accomplished corporate executive. And yet those high standards of achievement in their educations and professional accomplishments have had apparently very little impact on the low level of administrative procedures followed by the Public Utilities Commission in protecting the people of the state. Radiation is not something that you want to gamble with. Causing people to pay when they don't have money for defective products is not something that should be imposed upon anyone under any circumstances, but particularly when the Public Utilities Commission is charged with the obligation of protecting the people from that very type of behavior. And unfortunately, we see too many times where the PUC is actually joined in as opposed to fought and eradicated those kinds of practices. I'd be happy to answer any questions, and I want to make sure everyone gets their
What
documents.
kind of relief are you looking for, Mike?
We have filed a motion with the Public Utilities Commission to request that Southern Cal Edison immediately stop collecting rates for the 4 steam generators that are defective, and that the what's called an order of reparations be issued, which is a term of art. I think we've probably heard the word reparations in other contexts, but in the utility law context, a reparation is a term of art which means you return that which you have improperly collected. So we're asking for that the Public Utilities Commission issue an order returning to ratepayers the monies that have been collected over the last 2 years, and that the application or the advice letter for 2013 be denied forthwith, and that the money be returned, and that a deadline be set for the Southern Cal Edison to file their cost application, and if they let that deadline pass, then they have basically given up any opportunity to recover for the steam generator costs.
The box issue is a separate issue, although it kind of it made what you're pointing to appear worse. The question is, can you point to any intent to defraud the ratepayers, or was this, as far as you can point to, just a coincidence and an accident that they didn't? Do you have any documentation that shows that there was intent to defraud?
Well, we prove intent to defraud since we never can look inside someone's mind by the reasonable and
Notes,
probable.
emails?
Well, we prove this by the probable and likely consequences of actions. When you file something with the Securities and Exchange Commission saying you're going to file your cost application, and then you don't file it, when you do that repeatedly, when documents surface like the document with Senator Boxer that indicates that there were red flags that were ignored, or when you sent in for costs in December 31st of 2012, where you now know that your generators are not working, from there you can discern, I think, a strong argument that Southern California Edison did not act with anything other than intent and knowledge, and I couple that especially with the expertise that they bring to the table. These are amongst the most highly trained. Their lawyer is a former Supreme Court Justice law clerk for Clarence Thomas. This is one of the most gifted lawyers that you're going to find out there in the field. They have experts across the board, and now they're starting to respond by saying, well, we're going to file it in March of 2013. So I think that it's not accidental. The degree of culpability, however, needs to be investigated, and I think that what we're saying here today is that there is a sufficient basis to request that the Justice Department step in and conduct a thorough grand jury investigation to determine if any of our federal laws have been violated. And I think that's really the question. I think you raise a good point that this isn't the time to make a conclusion about it, but we certainly can. This is the time to start the investigation. And with an investigation, there's certainly a sufficient basis to start asking those questions.
Have you
Back to the
broken it down in
reparations
terms of
question.
how much
Back to the
each
reparations
repair?
question.
Right.
How much are we talking?
Well, you're talking about. I'll come back to that.
There's that question.
Okay, you're talking about 115 million for 2011, 115 million for 2012. So that's 230 million. And then they're asking for 140 million for 2013. And by the way, the cost of the steam generators has been financed. So although it says $700 million, you can do the math on the financing of that. It's not just $700 million. You're talking about sizable payments every year, for the next several years. And one of the things that we're asking Southern California Edison to do is to come clean for the real costs of these steam generators when you factor in the financing costs as well.
Have you broke it down into what each ratepayer might have been overcharged and could look to get back?
I have seen that done, but that's another thing that we're asking Southern California Edison to do for us. But I think that I look at it more like in this way. To me, the wrong here is to charge for something that you knew may be defective, and you could have taken steps to make those steam generators not defective, but you didn't want to have to go through the proper process of licensing. The same is true now. I think, if Southern California Edison would have applied for their cost, or made their cost application in 2011, that might have gotten approved. But now, in 2013, they may have really stepped on their own toes, because I think you'd have to be quite an advocate to be able to prove now that those steam generators and the money that you spent for them were reasonable.
Would you
Mike-
still be taking the same stand if those generators were not defective?
I think you could take that stand. I think you could take that stand, but it would be more. It would not be an egregious case. I don't think it would be something that would be worthy of a news conference and of a concern. I just say this: ask yourself, what would have happened to any of you if you would have expended money inappropriately and then not come back and accounted for the money you spent. My partner said this well. She said, they rather ask for forgiveness than for permission.
Yeah.
And the PUC gave them a blank check, and I think that had SCE been spending its own money, I think that you would have probably had more care, and they would have been more careful. But they were spending ratepayer money. In a way, it's kind of another type of bailout. It's go spend whatever money, other people's money, as much as you want, and if you can justify it later, great, and if not, we're really not going to hold you accountable.
Mike, what's the reality, though, of ratepayers seeing any of that money back?
Well, if you would ask me, a year ago, what is the reality that ratepayers wouldn't be charged the $1 billion that San Diego Gas and Electric was attempting to charge them because of the fire, and they were turned down? I would say that we're on a new paradigm with the Public Utilities Commission, because for years now, no one's really been paying attention except for the most intense advocates. One of the things we've discovered is that politicians don't feel good about their constituents being charged hundreds of millions of dollars for defects or for fire costs that by a company that started the fire. And that one of the things we're starting to see is that where the media gets involved and raises public attention, and it becomes an issue where people have an awareness, makes it much more difficult for the Public Utilities Commission to do anything other than that. What's the answer? You were supposed to come in with a cost application. You didn't come in with a cost application. You charged the ratepayers anyway. And now that you've been caught, we're just going to let you keep the money? Is that the new rule of the game? And what does that do to our system? I think that's a hard case to make. And I think what I saw last time is that our state senators and our state assembly persons received a ton of phone calls, and that's what we're asking people to do now as well, is to make those calls. The commissioners got those calls, they got the message. And I have to say this, because of the courage of Senator Boxer and Representative Markey for coming forward like they did, that was a very heavy thing that they did, the sending the letter. And we have a copy of the letter attached here to these documents. Where they basically said, hey, this company looked like they had a pretty good idea of what was going on. I think those kinds of things, when you have people hitting from a number of different directions, you have a very good chance to see that people are going to get their money back, and that this should be borne by the investors. People invest in these companies for a profit motive. They take a risk. The ratepayers are innocent victims who simply pay to have electricity. The idea that they have to pay because of corporate mistakes that were not prudently and reasonably incurred or made, and that they're to let the shareholders off the hook, that's what, we live in a free market economy. That's what the ratepayers are not taking on that risk, and the shareholders are taking on the risk, and that's where it should reside. Okay, well, thank you all very, very much.